Hi everybody, my name is Stina Holmberg and I'm a researcher at the National Council for Crime Prevention in Brå. And I will talk about a study that I and my colleague Lars Levenhagen has done about the new consent law in Sweden. And I had looked forward to discuss these questions with you at a seminar in Norway this spring. But today Corona rules, so we have to do it this way. But if you have any questions about the things I say, so you're very welcome to contact me afterwards, either by telephone or by mail. And that is stina.holmberg at bra.se. Okay, then I start. The new consent law in Sweden was both welcome and criticized. The changes had been long requested by women's organization as an important societal message, and they were very happy that it finally came into law. But on the other hand, the proposed law was strongly criticized by several influential legal bodies, especially the Council on Legislation, which is the strongest, most important remittal instance in Sweden. And they said that the problems with its applications can result in compromised legal certainty. And for that reason, the government asked Brå to follow up the effects of the law and how well it has worked during these first years. And the basics of the new rules, it is that it's considered as rape to have sex with someone who does not take part voluntarily. If the perpetrator is aware of that fact, it is an intentional rape. If he or she is not aware of that, but knew that there was a risk for it, it is considered reckless rape. And that is a new law paragraph, reckless rape, that has not existed in the Swedish law before. And the new rules came into force in July 2018. And first I will say that we focus in our study only on rape against grown-up women. And we concentrate on women because we did that in our earlier study from 2017, where because we want to compare the results in that study with the one that we have made now. And the themes they are that we studied trends in rape reports, prosecutions and convictions since the law was changed. And we study if the intentions of the legislator has been realized. And we ask if there are problems with the interpretation of the law rules and with evidence. And lastly, we studied the consequences as regards to the length of prison sentences for rape. And we have collected a lot of different data. First, crime statistics, and then we went through and read all court verdicts in rape cases in 2019. And by doing that, we identified some cases that we considered or asked, would this really be an illegal act before the law change, or is it a so-called new verdict? And in these cases, we contacted the responsible prosecutor and asked if they considered it to be a new case that they wouldn't have prosecuted before the law change. And that way we found 76 so-called new cases that had gone to court. And we read them very thoroughly and to get a picture of the problems with the new law. And we also sent out surveys to prosecutors, judges and defense lawyers about their opinion about the law. how well it works, and interviewed police officers. And we gathered views from 3 organizations who work with questions of rape. And when it comes to trends in crime statistics, we can see that the number of reported rapes have continued to rise after the change in law. We might have expected that there would be a sharper increase in the reports after the law change, as women saw that things that they didn't think was any chance to get a conviction for now was illegal. But we see that the increase follows the same increased trend as before the law change. So it's uncertain to know whether the increase this last period depends on other things like changed attitudes and continuing Me Too, or if it's an effect of the law change. And we hope to be able to study this more thoroughly in some later study. But what we see is that the number of convictions for rape has increased significantly after the law change. Rape convictions increased by 75% in 2019 compared to 2017, when we did our last study and went through all the convictions, from 190 to 333. And 26 of the convictions concerned new rapes and 12 concerned negligent, difficult word to say, rape. And as you can see, the new cases don't explain the whole increase of convictions. That means that most of the increase concerned so-called old types of cases, which means that they were illegal already before. The case that the prosecutor took up and argued about what had happened, that it had been with violence or using a especially vulnerable situation for the victim. But it seems that the new law creates a new floor for the court's decision. So even if they can't prove that there was violence, they can still prove that it was without consent and then get a conviction. So that means that the new law has had a wider impact on the rape convictions than just the new cases. And just to illustrate it a bit more, you can see that the trend in the number of rape convictions, it increased. It was stable for a few years before the law change, and then it increased a bit to 2018, and the law was only in force for half 2018, and then it took a real jump up in 2019. So a very clear effect of the new rules. What is the nature then of those 76 new cases that have gone to court? Well, overall, it's about young people who have partied and so-called ended up in a sexual situation that got out of hand. And the parties are often sharing a bed when the incident occurs. For instance, that there has been a party and many of the participants sleep over beside each other in beds, and then things can happen even though either if they've flirted early in the evening or just ended up in the same bed. It's less common with couples in those new court cases. It's most often acquaintances, and one way to interpret this is that a lot of these new cases is a consequence of that the parties don't know each other and don't communicate verbally enough, so they guess what the other the men guess what they think the girl wants, and then it turns out that that was not at all what she wanted. So that explains why couples, I think, are less common in the new cases. It's also interesting to see that the conviction rate for the new cases is not so very high, so far at least. Half of the new cases that went to court were acquitted, and half went to a conviction. And that could be important to remember, but because to be in a court case could be a trauma both for the girl but also for the suspect, then that one would hope that the conviction rate increased so that the prosecutors can sense more clearly what will be judged as illegal. What is then our overall picture of the law application? And our picture is that the new law has been applied without problem in most cases that resulted in a conviction for intentional rape. There were clearly punishable acts, and mostly there were evidence other than just witness testimony. So that was rather strong evidence. And several of the cases that were led to a conviction involve situations that mirror exactly those that were mentioned in the proposal for the new law. And that is that the victim was taken by surprise. A rather common case is that they lie in the same bed after a party and she is half asleep, and then she notices that the man or the boy beside her has put a finger into her vagina. And the other cases is some kind of frozen fright, that the woman has been passive due to more or less fear. And that was to some extent illegal already before, but now more cases have been convicted where there was passivity. And the problems interpreting the new law arise primarily in verdicts on negligent rape. And to tell you a bit about what kind of difficulties that arise when the courts should apply the new law and decide whether the thing that had gone on was illegal or not. And one is, when is a yes from the complainant invalid? Because it says in the law that so-called tjat sex, persuasion sex, is legal. That is not a rape to persuade someone to say, okay then. But where is the line between tjat sex and sexual coercion? When could you say that the situation was such that the girl had the freedom and felt free to not say yes, to say no? And there have been some cases where this is a difficult decision, according to Lasse's and my view. And another sign is, when is passivity a sign of consent and when is it not? And there you see that it plays a strong part in the decision what has happened before the reported activity. That if you have, if there are signs of consent early in the evening, flirting, then the decision from the court might be different from someone who has not given any sign of interest and then lies passive when something happens. What is the significance of an earlier no from the complainant in the assessment of the act? How far does a no continue to be ruling if other signs are shown later in the evening? So even though the convicted cases are clear cases that really work, we can also see that there are border cases that are not easy for the courts to decide. And also, what is gross negligence? That is a new law paragraph. And that is a line that is difficult to draw. Often it's argued from the courts about what did the accused think and understand when the incident or during the act. Did he realize that there was a risk that he didn't want to take part, or did he not realize that? And what we can see is that there might be a risk that accused with large good verbal skills about how they thought and what a good person they are, that they have a greater chance not to be convicted than someone who can't speak Swedish very well or isn't very verbal. Our last question was also what effects have the new law had on the punishment level. And we can see that the new cases often, but not always, result in the minimum penalty, which means 2 years punishment. Negligent rape results in an average prison sentence of 9.5 months. And already lawful acts now result in prison sentences that on the average are 2 months longer than before, which means 28 months. And we also collected opinions from different parts of the criminal justice system. And we could then see that the police officers that perhaps came the most close to both parties when they when they interrogate them, they had both positive and negative opinions. They didn't think that the prosecutors always could tell them clearly what kind of evidence that was important to gather. And they could also see that sometimes it was not easy to say that one of the parties was much more responsible for what had happened than the other. But they also saw positive effects, that young girls got a better protection than before, or women on the whole. The prosecutors, they are generally very positive. Almost no one had any critique on the law. It's an important message to society, was their general view. Judges, they have a limited experience of using the new law because there haven't been so many, and there are many cases and there are many judges. So, but overall, they haven't faced many problems themselves. But on the other hand, defense lawyers were very negative to the law. They find it too ambiguous and leading to that the legal certainty was compromised, and they found it difficult to explain to the clients what the law meant in the very specific case. And many side, not just the defense lawyers, but also the others, that the line between intent and negligence is difficult to draw. So now we come to Brå's assessment, and we think that the intentions of the legislators have been realized in several respects, and it has been possible to use it, we think, in a safe way. And it has been a signal of respect and empowerment for women in sexual situations. But the law, however, also has resulted in problems drawing a line between legal and illegal acts. But despite this, the new convictions for intentional rape have most often not been close to such lines, and we hope that it will continue like this. But we think that the verdicts on negligent rape are more problematic. Quite often we think that a verdict of rape, as intentional rape, or an acquittal appears to be a more logical choice. What that line in between of those other decisions is not easy to draw. And we also think, when it comes to this paragraph, that sometimes we wonder if the legal protection for those who are reported but acquitted perhaps not is always sufficiently strong. And you shouldn't forget that it can be very traumatic to be reported for a sex crime, even if you're proven innocent or not, or acquitted, because people think that, well, no smoke without a fire. And several mothers have actually called me and told me about their sons who have been acquitted but got their future very, very affected, so to say. So we need more precedents to help the courts to draw the line between legal and illegal, and so that they know better when to go to court with cases. And we also think that it's important to continue monitoring how the law is applied, because it's a very nice tool, but it has to be used in the best way possible. And if you want to read the report either in Swedish or parts of it in English, you can go to our website, Brå's website, and either look for this report or the English summary. Thank you.